This matter comes before the court at this time for a special set conference regarding the case that's set to start for jury trial tomorrow morning. What announcement is made at this time?
We'd like to enter a plea, Your Honor.
Okay, in this case?
Yes, Your Honor.
Okay.
Your Honor.
Okay, go ahead.
Your Honor, the plea is actually not in 25 CR 123. It's actually in 25 CR 309.
Okay, that is not a case I have before me. What is the charge in that case, Ms. Norris?
Your Honor, the original charging document is a violation of protective order. And state would be amending the information to basically allege 3 counts of violation of protective order, encompassing June 15, June 16. I'm sorry, I think June 16, June 17, and June 18.
Class A misdemeanors?
They are all Class A person misdemeanors, Your Honor, that's correct. And in exchange for the plea in the 309 case, the state would just be dismissing 25 CR 123 in its entirety.
Okay, so again, the case number that he would be entering the plea in is 2025 CR 309?
That's correct, Your Honor. And Your Honor, that case is next set in front of Judge Webster on November 3rd.
Has an amended charging document been filed in the 309 case?
It has not yet been filed, no, Your Honor.
All right. Mr. Kuhn, Ms. Norris has made an announcement regarding her understanding as to how these 2 cases would be handled. Are you in agreement with this announcement?
I am, Your Honor.
All right. Importantly, Mr. Ayers, apparently you would resolve 2 cases by entering pleas of guilty, I presume?
Yes, Your Honor.
All right. Guilty to 3 counts of violation of a protection order, all Class A person misdemeanors. Is that really your intention?
Yes, Your Honor.
All right. You understand that Class A misdemeanors are punishable by up to a $2,500 fine and up to 1 year in the county jail for each count?
Yes, Your Honor.
Mr. Ayers, according to the state, these took place June 16, 17, and 18 of the year 2025. Is that when these events happened?
I believe so, Your Honor. Yes.
At that time, did you have some sort of restraining order in effect?
Yes.
From what case?
From her saying that
Well, no. There was some sort of court case that issued a restraining order. So I'm asking you what court case that was.
It was a PFA court case, Your Honor.
Your Honor, the charging document sets forth that it's 25 CR 123. Basically, the case of the criminal threat that was before the court. There was a no contact order issued as a bond condition.
All right, Mr. Ayers, do you acknowledge that?
yes, Your Honor.
Okay, so you had a restraining order that was issued as a condition of bond. And then on the June 16, 17, and 18, you violated that restraining order according to what appears to be your guilty plea to these 3 counts. So what did you do to violate the orders?
I texted her about my son's birthday that she hadn't talked to yet. He told me that she was the only one that hadn't texted him, and it upset me a little bit. And so I texted her about it.
Even though you had a restraining order in effect not to contact her?
Yeah, I wasn't thinking about that.
Well, okay. That's recognized by the court. All right. So do you now freely, knowingly, and voluntarily enter pleas of guilty and accept conviction for 3 counts of violation of a protection order, Class A person misdemeanors?
Yes, Your Honor.
All right. Court finds that this is a free and voluntary act, that the defendant's been made aware of the possible penalties, and there is a factual basis to support 3 different counts based on 3 different incidents on 3 separate days. The defendant's pleas of guilty are accepted by the court, and the court finds him convicted of 3 counts of Class A person misdemeanor violation of a protection order. The court will proceed to sentencing at this time. And announce that according to the plea agreement, the entirety of case number 2025 CR 123 is dismissed. Ms. Norris, do you have sentencing recommendations here?
Yes, Your Honor.
Okay, you may deliver those at this time.
Your Honor, regarding count 1 violation of protective order, ask the court to assign defendant to 6 months in the county jail. On count 2 violation of protective order, 6 months in the county jail. And on count 3 violation of protective order, 6 months in the county jail. These counts to run consecutive for a total underlying sentence of 18 months in the county jail. The defendant successfully complete a domestic violence offender assessment and follow any recommendations. That he participate and successfully complete an anger management class. Costs and fees of the action to be assessed to the defendant. There is no fine or restitution. There is a domestic divorce case, and we would just ask that he abide by the domestic case / parenting plan, whatever's set out in that. 12 months non-reporting probation with standard conditions, basically not to violate the law, and no contact with the victim, Hannah Ayers.
Did you say non-reporting probation?
Yes, Your Honor.
Then how are the requirements to pay in the case, obtain a domestic violence assessment and presumably abide by recommendations and completion of an anger management class? How are those going to be monitored?
Your Honor, it's my understanding that Mr. Kuhn will be assisting with that, and then obviously our office will have to kind of keep tabs on it to make sure that all of those things are complete in 12 months.
And I will be assisting their office. We will make sure everything is completed, Your Honor.
Do you have additional sentencing recommendations, Mr. Kuhn?
Going for the underlying sentences are a little bit stiff for what happened, I believe. Mr. Ayers does recognize the significance of the no contact order, and probation is appropriate, Your Honor.
Mr. Ayers, the court will address you personally, and I'll ask you, do you have any statements that you wish to make in mitigation of punishment or anything further that you personally would like to present to the court?
I'm just still a little confused on how false allegations can lead to me having these, but I understand now that it's different with the contact order. Hannah also had contacted me. I did not know I could not contact her back. So prior to that, she had contacted me. I was unaware, of that, honestly. I'm a single parent running everything with trying to keep everything good for the kids. I'm not trying to be combative or I'm trying to be compliant and do everything everybody asks. It's just, I also have a job full time.
What do you do, Mr. Ayers?
I'm the lead at Spirit of the stretch press.
Okay. And how many children do you have with Hannah, the victim in this case?
One biological child, and then Preston is her stepchild, but now he's not, apparently, is what she's written down. She wrote ex-stepchild.
Okay. Well, Ms. Norris, how do you envision that Mr. Ayers is going to communicate with Hannah, the mother of the child that they have together, if there's a no contact and no communication restriction on him?
Your Honor, that's her request. And both of the kids have phones. Preston is 16, and Peyton is 13. But both of the kids have their own phones. And I did actually make a point to clarify that regarding communication between them regarding the children. They've been divorced for a year and a half, something like that, maybe 2 years now. Like I said, that she wants no contact. And so that's what I'd ask that the court order at this point. And it's my understanding that they don't seem to, when I was discussing that briefly with Mr. Kuhn, they did not seem to have concerns about it, or at least if they did, they didn't express those to me. But we did try to clarify and make sure that was accurate, and that's my understanding, so.
All right, very well. Court will pronounce sentence in this case on the 3 counts of violation of a protection order, all Class A person misdemeanors. On count 1, court will not impose a fine, but will order 6 months in the Butler County Jail. On count 2, no fine. Court imposes 6 months in the Butler County Jail. On count 3, 6 months in the Butler County Jail and no fine. The court will run counts 1, 2, and 3 consecutively with one another for an overall controlling sentence of 18 months in the Butler County Jail. This court has some hesitation with some of the recommendations that have been made here. However, Mr. Ayers, it would be a major break for you, I suppose, not to have reporting probation. You still have these requirements, which the court will order, that you obtain a domestic violence offender assessment and abide by the recommendations of that assessment. And whether this is part of those recommendations or not, there will be an independent requirement that you successfully complete an appropriate anger management course. Now, if there's any question about what qualifies, I suppose that question needs to be put to the prosecutor's office, since they're going to be monitoring this case to see what they believe satisfies that requirement. The court will be assessing a misdemeanor docket fee in this case. Counsel is retained, so the court need not assess bids assessments in the case. Are you aware of any other specific costs, Ms. Norris?
Don't believe so, Your Honor.
This court will be assessing, because of the nature of these crimes being rooted in domestic violence, the court will assess a $100 domestic violence programs fee to this defendant as part of the cost in the case. Mr. Ayers, you have a good job, and I know you may have your plate full financially at any given time, but I'm going to require that you pay on this case fairly quickly to get it paid off. Starting with the calendar month of October, you need to start paying at least $100 a month on this until you get it paid off. You should have it paid off by the end of the year. Any reason that you can see that you can't do that?
No, Your Honor.
Okay, 100 a month, starting with the calendar month of October, and again, every subsequent month until paid in full. Regarding the no contact restriction, the court understands, I think, the wishes of the victim in this case. The court just simply finds a no contact and no communication order to be impractical in light of the fact that you apparently have a biological child who has not reached adulthood. There may be some communication that still needs to take place between you and her. Mr. Ayers, do you have her email address?
Yes.
Okay. Do you have her phone number?
Yes, Your Honor.
Okay. The court will authorize you to make peaceful and non-harassing contacts with her about the child that you have together by text message or by email. The court's going to bar you at this point from any in-person contact with her and any telephone audio conversations with her. And I know there may be some emergency crisis that come up, but for now, I think I'm just going to restrict you to text message and email communications. And there's a purpose for that, Mr. Ayers. If the tone of this changes and it's something other than what the court allows, there'll be a record of what you've said. And you need to be very, very careful with any communication that you make with somebody who wants no contact with you whatsoever. But asking about the welfare of your son or communicating something about the child that you have together seems quite legitimate to this court. But you need to really restrict it to just that without any type of hateful invective going along with it. Do you have any questions about that, Mr. Ayers?
No, Your Honor.
It's a limited privilege, which I hope you do not misuse, because you're the one that's going to get in trouble for it. Now, if she sends you a communication, you can respond appropriately and peacefully back, okay? And you can initiate a peaceful and non-harassing communication as long as it's about the child that you have together. Okay?
Okay. Yes, Your Honor.
But you might want to talk to your lawyer about the situations where that would really be appropriate, because apparently she's pretty upset with you and doesn't want any communication or contact with you whatsoever. If you're in a public place, you run into her, you need to just get your business done and get away from her so that you're not accused of doing something you don't intend.
What
Okay.
about volleyball games for my daughter?
As far as I'm concerned, you can go to your daughter's volleyball games. Okay.
All right. Thank you.
I would always take into account where she's sitting and sit somewhere totally away from her.
Absolutely.
Okay. And in that context, you can't even communicate with her. Not by sign, just ignore her like she's a complete stranger. But I'm not going to keep you from going to the events that involve the child that you have together. Okay.
Thank you, Your Honor.
Again, a privilege which I hope you do not misuse. All right. Again, this will be a non-reporting probation for a period of 1 year. We start having problems with trailers, that very well could mature into a reporting probation. But I think you understand the rules, and I just hope you follow them, and then we won't have any reason to review your sentence.
We won't, Your Honor.
Okay, the other thing I wanted to make sure that I emphasized here, Mr. Ayers, I am not altering any existing or even future civil restraining orders which may exist. You have to comply with civil restraining orders. Okay. I'm only making orders that apply to this criminal case. Okay. So the limited privileges on communication that I'm allowing pertains to this case and its restrictions only. Any questions about that?
No, Your Honor.
Okay. All right, Ms. Norris, do you need any further clarification regarding the court's orders on sentencing made here today?
I don't believe so, Your Honor. Thank you.
All right, Mr. Kuhn, do you need any clarification? Do you have any questions regarding the court sentencing orders?
No, Your Honor.
Mr. Ayers, importantly, I want to ask you personally, you can always discuss this with your lawyer, but do you have any questions regarding the court's orders made here today?
No, Your Honor.
Okay, good luck. I just hope that you can peacefully coexist in the world without trouble.
Thank you.
All right. Obviously, this case is taken off tomorrow's jury trial docket. That jury trial and its jury that goes along with it will be canceled. Please, counsel, we're able to get these matters worked out, at least for now. If there's nothing further, the Chad William Ayers matters will currently be in recess. This meeting may be ended for all at this time.